Hello, today we'll be talking about terms and conditions and reviewing a legal case in which the plaintiff is trying to sue the defendant on whether or not they legally owe the plaintiff for stealing their product.
We'll be talking about the Wilson versus Kellogg case, which is focusing on the terms and conditions and whether or not Kellogg violated any law in regards to terms and conditions. So, first of all, what is terms and conditions? Well, it's a document governing the contractual relationship between the provider of a service and its users for many different things. Under Michigan law, the submitter is the one entering into the contract with the manufacturer. In regards to that, terms and conditions can protect the manufacturer from lawsuits or any sort of suit against them for anything. So once you agree to the term and conditions of the manufacturer, there are certain restrictions on what you can sue for and what you can't. So what this entails is the plaintiff wanted to submit an idea to the idea portal of Kellogg about an idea for a breakfast drink, and the claim was against the manufacturer for a breach of contract. And according to references, it states that the motion to dismiss the suit was because the submitter only made vague references to terms and conditions, where the submitter made deliberate decisions to avoid any reference to the terms and conditions for the complaint, according to the federal civil procedure.
So when thinking about contracts, right, they are things that you do every single day. You agree on service, stuff like that. Well, while it may be said that it's slightly different than a contract per se, it is a contract in which the owner they clarify the conditions to use the service. So if you use Netflix, Hulu, Spotify, any sort of thing, website or service of any matter, you are both doing contract and terms and conditions. Because every single time you make an account, you agree to the privacy policy, the terms and conditions, all those kinds of stuff. So, for example, let's say you were to go and make a Spotify account through using Google, right? In order to begin, you have to start with making a Google account of the matter. And it requires you to go through the privacy policy, the terms and conditions, the sort of the rules or the guidelines in order to use the service. Because obviously, with everything, you don't really need to use a service per se. So, obviously, the terms and conditions are the legal bindings of a given contract to use those services. After that, once you make that account, you gotta go through Spotify and agree to their terms. So obviously there are reasons behind that. So there's no legal loopholes in that matter, and you can't just go and sue for whatever reason, because with every single contract there's certain restrictions that you have, which by accepting those, you agreed to them in order to make the account. So as a result, with making these accounts and using these services that are out there, you have to go with those rules and guidelines in order to use the services. Otherwise, you will not be permitted to use those services, and they can refuse your own access if you break those rules or guidelines. And you can't just fight them in court for those certain rules. An example is I use Spotify, I use HBO Max, I use all these different platforms, Instagram, Twitter, you can even say Facebook for that matter. Any of those are examples that you can find that have a terms and conditions. Video games that you play, all kinds of media, they all have terms and conditions. Companies, websites, everything in those areas, among others. So obviously, contracts are only considered valid when all parties are in agreement for the terms. But there is an exception where a contract can be voided and invalid. In that case is if the express terms that are on the terms and conditions are not accurate. So let's say you have something in regards to, mm, yeah, you have access to all these utilities as long as you use the service and like for free. But later, it is entirely false. Then that is a voided contract in regards to not being accurate.
So according to the materials, the court may consider on a motion to dismiss. And the reason for that is the basis of Kellogg to dismiss the case. Plaintiff Wilson was required to agree to the terms and conditions prior to submitting the idea. So according as well from the Westlaw article from Unjust Enrichment, the plaintiff's second cause of action, according to it on line 22, 314 for unjust enrichment. Plaintiff's second cause of the action alleges that Kellogg has been unjustly enriched by the use of plaintiff's breakfast drink proposal. While that may be a possibility, there is certain terms and conditions of how Kellogg runs it. So in this case, Kellogg is not required to compensate Wilson in any way for the use of the breakfast drink. The company in question is not in any way breaking any law in regards to the usage of the idea, because an idea that is not patented or any way protected from the reproduction of the items, there's no evidence that can back up the plaintiff. Kellogg can use that product and not compensate. I can stand by Kellogg for the use of the product.
Now, it may not seem viable to look at every single terms and conditions. You go to all these kinds of sites. It's just impossible. Because who does that? Who goes and reads every single line that you're agreeing to? Well, if it's something that is a monetary value, such as the example with this case and the breakfast idea, review the terms before agreeing to them, as you may not know what exactly you're agreeing to and what you're getting yourself into. It's just a way that, this guy could have prevented that or may not have gone through with it, because at the end of the day, you can't really fight Kellogg for something that you agreed to contractually through the terms and conditions.
So if you were to go and give ideas, it better have a pattern, because if you don't have a pattern on it and you don't allow them, they don't have to pay you a dime. So, and there's many examples. If you don't have a patent on that, you're kind of a lost cause, because they can do what they want legally.